They are showing us glimpses of the Ninth Circuit of old. This is the one on gun shows. Let's talk about it. Hey everybody, welcome back to the channel today. That's right, we had two lawsuits that were previously argued at the Ninth Circuit. These are the lawsuits pertaining to the gun shows and the purchasing of firearms on state-owned property. Here to walk us through that, a partner at Michelle & Associates. She's the one who did the oral argument at the Ninth Circuit for these cases. That is Anna Barver. Anna, thank you for being with us today.
You're welcome. Thank you for having me.
Absolutely. But before we get into that today, guys, it is working. Please like, share, and subscribe to these videos. Hit that little notification bell so that you get notified as these videos come out. As always, we want to bring you the most up-to-date information on litigation, legislation, and what is going on with the firearms community. So, Anna, if we can just jump right into this here, we've got two lawsuits at the Ninth Circuit. In this particular oral argument, you argued them back to back. Seemingly, it was kind of like one big oral argument. For both of these cases, though, can you just kind of give us a brief overview on what took them up to the Ninth Circuit?
That's a really good question. So both of these, we call them the gun show cases, brought on behalf of B&L Productions or Crossroads, as well as CRPA and a number of individuals. These were challenges to California state laws that bar the sale of firearms, ammunition, and firearm precursor parts on any buildings that make up the Del Mar Fairgrounds, buildings that make up the OC Fair and Event Center, and now any properties that are owned by the state in California. We brought lawsuits in the Southern District of California challenging the ban at the Del Mar Fairgrounds. We brought a challenge in Orange County in the Central District challenging the OC Fair and Event Center ban, as well as the statewide ban. In the Southern District Del Mar lawsuit, we lost on a motion to dismiss. That means it didn't get through the pleadings. There was no answer. There was no discovery. There were no facts except what we pled, and we lost on all counts: First Amendment, Second Amendment, and equal protection. In the Central District, on the other hand, we won a motion for preliminary injunction on all grounds, on First Amendment, Second Amendment, and equal protection, and our claims that gun shows were effectively being banned on all state-owned property, especially including the OC Fair and Event Center. That motion for preliminary injunction went into immediate effect, and gun shows are now happening at the OC Fair and Event Center per court order. We then we took an appeal of the motion to dismiss lost in the Southern District, and the state took an appeal of the motion, their promotion for preliminary injunction loss. Both cases ended up being not necessarily consolidated, but they were related and heard together before the same panel so that we don't get differing decisions. And they were all heard last Wednesday.
Well, so you're basically saying you have two lawsuits that went in opposite directions. Both the state appealed one, we appealed the other one. Is this just the court trying not to duplicate its efforts? How is it that you find yourself in one court arguing both of those cases back to back?
That's a good question. So what ended up happening, it's a few things. We had initially asked, when we filed the appeal of the motion to dismiss, we asked the court in a motion right away to kind of just like hold the brakes, because we knew that there was going to be an appeal of the pending motion for preliminary injunction proceeding in the Central District. So we're like, we know this is coming. It's either going to be us or it's going to be them. So you should just wait. The court said, nah, go ahead and do the briefing, but we will reconsider this if and when that MPI case comes to us. When the MPI case did come to the Ninth Circuit, was appealed by the state asked that we hold the MPI, our motion for preliminary injunction win appeal, in abeyance indefinitely until a panel ruled on the motion to dismiss case, right? We opposed that and said, no, you should just hurry up the motion for preliminary injunction appeal and hear everything together so that there isn't duplication of work. And because we don't want two different panels to hear the identical legal questions and come to opposite conclusions, right? We want to have the same panel making the same ruling, good, bad, or indifferent, so that there is no confusion for all of the lower courts going forward or the parties going forward.
Well, I do have a couple of like substantive questions that I want to ask you about the lawsuits it's themselves. But before that, I got to tell you, I watched the oral argument and I kind of just wanted to give you a hug because the panel did not seem that favorable.
And severity of weighing interests. I'm not talking about weighing interests here. I'm talking about if it doesn't have an impact on the ability to keep and bear arms, how does the Second Amendment speak to it?
There were a couple of instances where one judge in particular, the bias was pretty out there, seemingly, at least from my perspective. I'm just sort of curious, going into that, do you understand who is on this panel? And while you're going through that, I mean, there are a couple instances where this guy was like literally yelling at you, waving his finger.
Because it's not highly attenuated. The plain text of the Second Amendment, keep and bear, necessarily includes those predicate acts. This court has held that repeatedly. And so,
And I've conceded that. I agree with that. The problem is that you're telling me that just because I got to cross the street to get it from over there, that's enough to trigger the Second Amendment protections. And that's what I don't understand.
I wouldn't necessarily expect that sort of thing to go on in a courtroom, but then here I am sitting here watching it. As you're going through that, what exactly are you thinking? And does that change at all your focus on how you're presenting your arguments?
So there was a few questions I got out of that. And first, yes, we do know who is going to be on the panel before we arrive. That is usually that information is usually released about a week to 2 weeks in advance. We do a little research on them, and we knew that this was going to be a hostile panel. We weren't expecting to find a win, I think, based on the makeup and the history of not only who appointed these judges, but also their decisions in the past. And you were mentioning the guy Judge Clifton. There were some things that we expected. We know that he wrote an anti-gun dissent in Young, in the Win in Young. So we knew that there was some that was going to be a speed bump that we had to deal with an anti-Second Amendment perspective. And I also kind of expected, based on First Amendment opinions I've seen of his, where he seems to be a little more siding with the government, even on a First Amendment free speech analysis, giving the government a little bit of deference when it comes to restrictions on speech. And since both of those are the meat and potatoes of this case, we knew that it was going to be tough. When you get in there and you're dealing with we call it a hot bench, one that is very, has a lot of questions for you, is not just sitting there and allowing you to give the presentation that you expected. I mean, these are things that we plan for. We do what we call moot court sessions, where we gather up a bunch of attorneys to review the documents in the case and ask as many questions as they can. But honestly, I was not expecting such a pushback from what, in my opinion, is a very obvious decision that came out, principle that came out of Bruin, which is we can't look at severities of the burden anymore. You cannot make a plaintiff, a challenger on the Second Amendment, say, I can't buy guns elsewhere before you start a history and tradition-based analysis. And so I was really surprised to get so much pushback from this court, because I couldn't get beyond that analysis, like trying to tell the court that Bruin says that we are done with severity of the burden analysis. We are telling you that this is a restriction on sales of lawful arms, firearms, ammo, and parts. And now you need to do a history and tradition analysis. They weren't having it. And you can say that as much as you want, and eventually you just have to tell the court that, you know what, I don't have something more appeasing for you. That is what Bruin said, and you're going to take it or you're going to leave it. It was frustrating, I'm not going to lie, but I think I was successful in continuing to hold my ground on telling the court that that is the analysis Bruin requires.
Well, yeah, and let's dig into that too, because there were a couple of things that I saw. One thing in particular, the opposing counsel wasn't really willing to get over, and one thing that the panel of judges wasn't really willing to get over. As far as the opposing counsel, he was very insistent on trying to separate what is a gun show and what is the sale of a firearm.
Keep and bear arms, yes. The The sale? Okay,
think
maybe
Bruin-
this is the case.
Can you go into that argument just a little bit? You know, when it comes to the legislation, when the legislation was going through, when the legislators were putting out statements about these laws, you know, there was a lot surrounding the word gun show because they were trying to end gun shows. At one point in your oral argument, I think you just kind of raised your hands and says, what is a gun show if you can't buy guns? But they were trying to separate those two things, stating that regardless of what the legislators said as they were pushing these laws through, this lawsuit is about the sale of firearms and the sale only. Can you read into that a little bit more? And I got to ask you, and I know you asked them, but as far as you're concerned, what is a gun show without the purchase of guns?
The reason this becomes a big question is obviously we've brought a First Amendment case. And so in order to have a First Amendment case, you have to establish that there's speech being restricted. And our theory of the case is several fold. At the very basic level of what the law says, it says that, employees, lessees, sublessees of these properties cannot contract for, authorize, or allow the sale of firearms, ammunition, or firearm precursor parts on these properties. And our position is that that is necessarily speech because you have to, first, contracting for, authorizing, and allowing involve speech and expressive conduct necessarily. But even when you're talking about just the word sale in the black and white letter of the law, you have to understand what a sale means. And in our everyday understanding of a sale, it's I'm going to put down money and I'm going to buy this gun. But in California, because of the way the law works, because you cannot put down money and take a gun home, you have to, and especially at a gun show, you can only do that 10 days later after a background check at the FFL's brick and mortar store, because they've bifurcated the meaning, the general understanding of a sale. The law wouldn't do anything if it only barred that part where you pick up and you give the money and you take the gun home, because that is already banned, right? Notwithstanding these laws, you can't do that anyway. So our position is that it has to include offer, advertising, the negotiation that people engage in when you're having a face-to-face firearm sale. All of that speech in our position is barred. Now, the state is trying to rewrite history and reinterpret the law for purposes of this lawsuit to say that no, you can totally advertise, you can totally have offers, you just can't sign the credit card slip. And that's silly when you look at both the plain language of the law, the plain definition of a sale and the way it works in California for firearms. And then when you look at the legislative history, so the legislative history was full of references to, we're banning gun shows. We are the first state in the nation to ban gun shows everywhere. That was obviously their intent. It was obviously the purpose, and it's been the effect. No shows had happened at either Del Mar or OC Fair and Event Center or any fairgrounds, state-owned fairgrounds in California since the laws took effect before we got our injunction, right? So that it was the purpose and it was the effect. You have to interpret it to mean that. And so not only our position, our theory is that not only is commercial speech, the offer and acceptance, the advertising of guns, ammo, and parts barred, but so is that pure educational and ideological speech that necessarily happens at gun shows. The advertising of CRPA to have to get membership, to advertise its events, to the ability of authors of books to sell their gun-related books, the sellers of beef jerky, like all of these things are being barred because the purpose and intent, and in fact, the effect of the law was not just to ban talky talk about gun sales. It was the actual event itself. And that's what's happened. The government, the court doesn't seem to believe us, but that isn't the place of this court. An appellate court has to take the factual findings that the motion for preliminary injunction court found, and it doesn't seem like it has a stomach to do that.
Well, and I'm sure they understand the ramifications. I mean, there are plenty of shows. If you go to a reptile show, you can buy bark, you can buy tanks, you can buy all this stuff. But if the reptiles aren't there, then people aren't going. And if people aren't going, there's no show. Same thing for a car show. You know, they selling T-shirts, they're selling beer, they're selling all this stuff. But if the cars aren't there, people aren't there, and then there's no show. It's almost like they're looking at this in a vacuum. And speaking of, you know, maybe them looking at something in a vacuum, and another interaction that I found very interesting was one of the judges ended up looking at you, and I think she asked, literally, I'm sure that you can agree with me in saying that guns can't be purchased anywhere. That's where you kind of stuck your finger up and was like, whoa, like we don't necessarily agree on that. What is the difference of preparing a statement like that when you have a judge on the Ninth Circuit panel who's coming from a place where she believes guns should not be able to be purchased anywhere, whereas I think your statement ended up being guns should be able to be purchased anywhere so long as they're subject to the limitations that was observed in Bruin?
Right. That kind of a question is a very clear question to try and get the oral advocate to concede something that's bad for their case. The judge is usually milling about on something, thinking, okay, this is what I'm thinking, but I need this last point conceded by counsel at argument. And you have to be really careful with that, because what I was trying to do is thread a very fine needle. This is a very nuanced answer, because I think it is clear that we aren't able to buy firearms and ammunition everywhere. I think I brought up this courtroom, for example. I was, there's going to be a restriction on buying and selling firearms in this courtroom. You can't even bring them in. But that limitation is not based on an understanding that the Second Amendment right itself does not implicate sales of firearms anywhere or everywhere. Surely the sales of firearms implicate the Second Amendment. But what you have to do is to determine if any narrowing or if any regulation is appropriate is to do the historical traditional analysis that Bruin made very clear. And that was what I was trying to explain to the court was, okay, yes, the Second Amendment clearly implicates and sales of firearms, lawful firearms, ammunition and parts clearly implicate Second Amendment conduct, so it's presumptively protected. So the state then has to decide whether or not there's a history and tradition of a certain restriction. Bans on bringing your guns into and selling them in the courtroom are probably going to be something that you see a historical support for. Bans on selling them at commercial locations that have been opened up by the state specifically for commercial behaviors, there is no history of that. And the court properly found that in the Central District.
Well, yeah, it certainly seemed like a panel that was maybe biased in the other direction. Where do you see, what are your final thoughts on these oral arguments? What are your final thoughts on where these cases are potentially headed going forward?
I'm not under any, I think, misguided hope that we're going to win. I think it was pretty clear that we had a hostile panel that wasn't following us down the road on any of our claims. But I'm hopeful because of the procedural posture of these cases, one being a motion to dismiss, where the court has to take our factual allegations from the complaint as true, and that there was plenty of times in the decision in the motion to dismiss case where the court didn't. It took the facts as alleged by the state. So that's just wrong procedurally. My hope is that the court will see that and will reverse on that. And we'll understand also that on a motion for preliminary injunction, it's a very high bar to overcome the factual findings of a lower court. But I'm not holding my breath that will happen. I expect some hijinks, and that would mean that our motion, we wouldn't lose the motion for preliminary injunction case entirely. That Orange County case would continue on to further judgment, but the motion to dismiss case would be final judgment. And I would highly expect that you're going to see us either seek en banc review or a Supreme Court review of that, because it would just be wrong.
Well, something certainly to follow along on, perhaps different paths that they take from here. We'll be certain to follow along on both. Anna, I know that you guys are super busy at the law firm. I want to thank you for these oral arguments, and I want to thank you for coming on and sharing your thoughts with us today.
Of course. Thanks again for having me.
Absolutely. And guys, if you like videos like this, you like the latest information on lawsuits happening in the Second Amendment community, please be sure to like, share, and subscribe to these videos. Hit that notification bell so that you get notified as they come out. As always, we are trying to make sure that people are as informed as possible when they go to the ballot box at the end of 2024 in those general elections. Thanks again, guys, and we'll see you on the next one.